For my alternative justice project, I chose to examine and analyze the jury system present within the United States. While the jury system isn't a popular section of our criminal justice system and often goes overlooked, it does prove to be a crucial element when examining some of the major goals of the criminal justice system, mostly when ensuring the safety of the public and ensuring that criminal processes are both entirely thorough and valid. We could see the importance of the jury system and the importance of improving our jury system. Did you know, well past its initial conception in 1630, our jury system has reinforced unfairness based on race, ethnicity, gender, and age? In fact, initial jurors were only land-owning white men, and this would persist until 1875's Civil Rights Act. While the Civil Rights Act outlawed race-based discrimination and jury selection, it wasn't until the 1986 Supreme Court decision in Batson versus Kentucky that racial preemptory strikes became unconstitutional. Further, it was even noted in the Supreme Court decision of Shepard versus Maxwell that our jury system is easily persuaded. This persuasion is mostly caused by the fact that jurors are chosen based on their disinterest in a case, as interest most often gets confused for bias. The following video provides a brief but enlightening look into the ways in which our juries are selected and also highlights some of the pre-existing criticisms that have surfaced.
A good citizen will perform basic civic duties. Your duty to serve on the jury goes with your right to trial by jury.
Here's how jury selection works. First, prospective jurors are picked for duty out of a large pool, usually a list of registered voters or licensed drivers. Then comes a process called voir dire, or to speak the truth. Prospective jurors are questioned by lawyers on both sides. They're looking for bias. Like in this scene in The Devil's Advocate, where a lawyer is trying to gauge the jury for bias against bankers.
Do you think as a juror, you would be able to set aside any prior opinion you might hold about the savings and loan industry?
If a lawyer has reason to believe a juror will be biased, they can ask the judge to dismiss the juror with cause. Each side can also strike a certain number of jurors without giving a reason. These are called peremptory challenges, and this is where things get tricky. While lawyers aren't technically allowed to use these challenges to discriminate on the basis of race or sex, that doesn't mean they don't try. Like in this scene in the TV show How to Get Away with Murder.
We have to look for jurors who are prone to distrust authority. What are some of the signifiers of this?
Number one is race. There's a larger distrust of police among Black Americans.
You don't call the police in my neighborhood.
The racial balance of a jury can impact the verdict. Studies have shown that all white juries are harsher on Black defendants, make more errors, and discuss less of the case facts. And in another study, in cases with a Black defendant and white victim, having one or more Black male jurors lowered the likelihood of a death sentence by a lot.
A difficult day for jurors in the O.J. Simpson murder trial.
It's why, in high-profile, racially charged trials like that of O.J. Simpson, so much attention was given to the fact that the jury had 9 Black members on it.
The jury has spoken.
And Simpson was acquitted.
Not guilty of the crime of murder.
There's also the disturbing case of Emmett Till. In 1955, 2 Mississippi men, Roy Bryant and J.W. Milam, were accused of kidnapping and brutally murdering a 14-year-old Black boy named Emmett Till. Bryant's wife alleged that the boy had touched her hand and waist and whistled at her in a grocery store. Emmett Till's body was found days later in the Tallahatchie River, beaten, shot, and tied to a cotton gin with a barbed wire. Bryant and Milam were arrested and charged with murder. But the trial of Bryant and Milam would be decided by a jury that consisted of 12 white men. Despite multiple witnesses seeing the 2 men take the boy, and one that saw the back of Milam's truck dripping with blood, a jury of 12 white neighbors of the defendants reached the verdict after 1 hour and 5 minutes of deliberations. The men would walk free. Decades later, Bryant's wife, who made that first accusation against Emmett Till, recanted her story. Fast forward 30 years from the case of Emmett Till, and all-white juries still weren't a thing of the past. In the 1986 case Batson versus Kentucky, a prosecutor used his peremptory challenges to remove all 4 Black jurors from the pool. The defendant's appeal made it all the way to the Supreme Court and won. Today, if one side suspects the other of using peremptory strikes to racially discriminate, they can file what's called a Batson challenge. But the problem is...
Yeah, so Batson is pretty much widely regarded as a failure.
If a lawyer accuses the other side of excluding a juror because of race, the judge then has to decide whether it's discriminatory. The accused would have to come up with a reason, any reason, that's race neutral for why they don't want the juror.
Courts have really allowed kind of any reason. For example, like an attorney might say, well, I struck all the people who seemed suspicious of the police. And so that would on its face be racially neutral, but it still kind of allows for that disproportionate impact.
You can see that in this leaked 1987 training video in which attorney Jack McMahon explains how to exclude Black people and get away with it.
There's the blacks from the low-income areas are less likely to convict. And as a result, you don't want those people on your jury. Batson versus Kentucky, I'm sure you've all become aware of that. Best way to avoid any problems with it is to protect yourself. When you do have a black jury, you question them at length, and on this little sheet that you have, mark something down that you can articulate. Say, well, the woman had a kid about the same age as the defendant, and I thought she'd be sympathetic to him, or she's unemployed, and I just don't like unemployed people because I find they're not too stable.
Are our trials truly fair? While the video showed most of the core issues with our jury selection method, other issues do arise when examining our jury system. To begin, one of the first issues with our jury system is the failure to ensure a proper understanding of the duties and responsibilities of the juror. With no formal education requirement, we as a nation cannot ensure that our juries are equipped to handle the cases they are. Also, when examining our jury, issues such as patchwork guilty trials arise. Patchwork guilty trials arise when members of a jury cannot agree on the extent to which a law was violated, but come to an agreement that it was violated, therefore sentencing the defendant. These issues are exemplified by the fact that our system does not require a formal education, therefore understandings of crime vastly differ. Oftentimes, patchwork guilty trials lead to wrongful imprisonment and even contribute to mass incarceration. Other studies completed have identified key issues with our current jury system, these being jury participation, jury instructions, and hung juries. All three of these concepts have detrimental consequences for our jury system, with jury participation being a key downfall. In fact, jurors are chosen based on their disinterest in a topic to avoid bias, but this method does not solve bias. Rather, it appoints disinterested people to decide cases that require some sense of commitment. Furthermore, when analyzing the current amount of instructions given to our jury, we as a society can notice a pivotal flaw. Continuing, even with concepts like a hung jury, we are able to notice the negative aspects on the surface. In fact, issues such as jury nullification date back to the mid-1800s and continue to plague our society. Jury nullification refers to instances where an individual is technically guilty of a crime, but due to the juror's understanding of the crime as immoral, the individual is found not guilty. Adding to this, a more current issue with our jury system falls on the system's lack of a unanimous verdict requirement. As most times in the current day, juries hear civil cases, the lack of a unanimous verdict requirement proves to be detrimental. With no formal education requirement and a dearth of instructions and solutions, we simply cannot believe that our jury system is as effective as possible, or even that it is an effective way to maintain justice. Moving forward, I'd like to highlight more of the key issues that have been observed within our jury system. While our jury system does allow for wage compensation for jurors who miss work, in most cases, individuals who are called for jury participation will effectively lose wages for the day once all factors have been accounted for. In addition to this, jurors may suffer from emotional harm. This harm could easily be prevented, but due to the lack of formal requirements, emotional harm for jurors remains a true possibility. Other negative aspects of our jury system revolve around the trend noted by Dr. Commissar in 1995 that jurors are easily persuaded, meaning that some cases do not receive justice. In fact, just about 90% of pleas are guilty pleas, which eliminates the trial by jury process. This statistic overwhelmingly expresses the public's fear of trial by jury and how this fear is used to persuade defendants into pleading guilty for plea deals, effectively contributing to mass incarceration. So the biggest question remaining is, how can we improve? Improvement, while challenging, is not impossible. One of the biggest improvements that can be made is the implementation of mandatory comprehensive tests for all prospective jurors. This test would serve to determine whether or not the prospective juror has grasped an understanding of the U.S. Constitution or even the laws that govern our land. This improvement would ensure that all jurors have an understanding of the task at hand. Furthermore, one of the biggest issues with our jury system, as mentioned before, is bias. And in order to effectively deal with selection bias and juror bias, we must reimagine our screening processes. Mainly, further investigation into social media posts and chosen jurors is essential. And while it is currently completed, it is not completed at the volume required to ensure justice and true fairness. Additionally, a component that needs improvement are the methods in which preemptory strikes are used. While our Supreme Court decided in Batson versus Kentucky that juries could not be victims of preemptory strikes based on race, other statuses like prone to distrust police and appears to be from inner city are two examples of quote-unquote legal alternatives. Reimagining these strikes may lead to a more diverse jury, which at the end of the day is essential in our society. Continuing, jurors must have access to a pretrial training program that accurately explains their duties and provides them with reliable methods to do so. Far too often, jurors are chosen and don't fully understand their duties or even the entirety of their responsibilities. With the implementation of both a pretrial training process and mid-trial summaries, our jury system will become more involved and suffer from less disinterest, therefore ensuring that the jury is more active in these cases. In conclusion, our current jury system is simply outdated. With little changes or adjustments made to the processes of picking jurors since its initial founding in 1630, our jury system promotes elements of hegemony. And in order to have an effective jury system present within our society, we must allow for change and necessary improvements to be made, especially in a time period characterized by change, but also the resurgence of activism. As mentioned in the previous slide, one of the ways that we could do this is by implementing a mandatory comprehension test in order to accurately gauge potential jurors' understanding of laws. Furthermore, by reimagining the voir dire process within the United States, we may be able to eliminate juror bias or even promote diversity, an element that our jury system has essentially lacked since its conception. In other words, without change and improvements, the essential elements and goals of our criminal justice system will never be possible due to the ways that our juries operate. Moving forward, without fundamental change to the ways in which juries are selected and even the ways in which juries are provided information, our jury system will continue to be plagued by deception, bias, and outdated procedures.